Constitution of India. Part 2. Citizenship. Article 10. Continuance of the rights of citizenship. Every person, who is, or is deemed to be a citizen of India, under any of the foregoing provisions, of this part shall, subject to the provisions of any law that may be made by Parliament, continue to be such citizen. Constitution of India. Part 2. Citizenship. Article 11. Parliament, to regulate the right of citizenship by law. Nothing in the foregoing provisions of this part, shall, derogate from the power of Parliament to make any provision with respect to the acquisition, and termination, of citizenship and all other matters relating to citizenship. Constitution of India. Part 3. Fundamental Rights. General. Article 12. Definition. In this part, unless the context otherwise requires, the state includes the Government and Parliament of India, and the Government and the legislature of each of the states, and all local or other authorities within the territory of India, or under the control of the Government of India. Constitution of India. Part 3. Fundamental Rights. General. Article 13. Laws, inconsistent with, or in derogation of the fundamental rights. All laws in force, in the territory of India, immediately before the commencement of this Constitution, in so far as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. The state shall not make any law, which takes away, or abridges, the rights conferred by this part, and any law, made in contravention of this clause, shall, to the extent of the contravention, be void. In this article, unless the context otherwise requires, law includes any ordinance, order, bylaw, rule, regulation, notification, custom or usage having, in the territory of India, the force of law. Laws in force includes laws passed or made by a legislature or other competent authority, in the territory of India, before the commencement of this Constitution, and not previously repealed, notwithstanding that any such law, or any part thereof, may not be then in operation, either at all, or in particular areas. Nothing in this article shall apply to any amendment of this Constitution, made under Article 368. Constitution of India. Part 3. Fundamental Rights. Right to equality. Article 14. Equality before law. The state shall not deny to any person equality before the law, or the equal protection of the laws within the territory of India. Constitution of India. Part 3. Fundamental Rights. Right to equality. Article 15. Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. No citizen shall, on grounds only of religion, race, caste, sex, place of birth or any of them, be subject to any disability, liability, restriction or condition, with regard to access to shops, public restaurants, hotels and places of public entertainment, or the use of wells, tanks, bathing ghats, roads and places of public resort, maintained wholly or partly out of state funds, or dedicated to the use of the general public. Nothing in this article shall prevent the state from making any special provision for women and children. Nothing in this article, or in Clause 2 of Article 29, shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens, or for the scheduled castes and the scheduled tribes. Nothing in this article or, in subclause G of Clause 1 of Article 19, shall prevent the state from making any special provision, by law, for the advancement of any socially and educationally backward classes of citizens, or for the scheduled castes or the scheduled tribes, insofar as such special provisions relate to their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in Clause 1 of Article 30. Nothing in this article or subclause G of Clause 1 of Article 19 or Clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any economically weaker sections of citizens, other than the classes mentioned in clauses 4 and 5. And any special provision for the advancement of any economically weaker sections of citizens other than the classes mentioned in clauses 4 and 5, insofar as such special provisions relate to their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in Clause 1 of Article 30, which in the case of reservation would be in addition to the existing reservations, and subject to a maximum of 10% of the total seats in each category. Explanation. For the purposes of this article, and Article 16, economically weaker sections shall be, such as, may be notified by the state, from time to time on the basis of family income, and other indicators of economic disadvantage. Constitution of India. Part 3. Fundamental Rights. Right to equality. Article 16. Equality of opportunity in matters of public employment. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. No citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, residence or any of them, be ineligible for, or discriminated against in respect of, any employment or office under the state. Nothing in this article shall prevent Parliament from making any law, prescribing, in regard to a class, or classes, of employment, or appointment to an office, under the government of, or any local or other authority, within a state or union territory. Any requirement as to residence within that state or union territory prior to such employment or appointment. Nothing in this article shall prevent the state from making any provision for the reservation of appointments, or posts, in favor of any backward class of citizens, which, in the opinion of the state, is not adequately represented in the services under the state. Nothing in this article shall prevent the state from making any provision for reservation in matters of promotion, with consequential seniority, to any class or classes of posts in the services under the state, in favor of the scheduled castes and the scheduled tribes, which, in the opinion of the state, are not adequately represented in the services under the state. Nothing in this article shall prevent the state from considering any unfilled vacancies of a year, which are reserved for being filled up in that year, in accordance with any provision for reservation made under Clause 4 or Clause 4a, as a separate class of vacancies to be filled up in any succeeding year, or years, and such class of vacancies shall not be considered together with the vacancies of the year in which they are being filled up for determining the ceiling of 50% reservation on total number of vacancies of that year. Nothing in this article shall affect the operation of any law, which provides that the incumbent of an office in connection with the affairs of any religious or denominational institution, or any member of the governing body thereof, shall be a person professing a particular religion or belonging to a particular denomination. Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any economically weaker sections of citizens, other than the classes mentioned in Clause 4, in addition to the existing reservation, and subject to a maximum of 10% of the posts in each category. Constitution of India. Part 3. Fundamental Rights. Right to equality. Article 17. Abolition of untouchability. Untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law. Constitution of India. Part 3. Fundamental Rights. Right to equality. Article 18. Abolition of titles. 1. No title, not being a military or academic distinction, shall be conferred by the state. 2. No citizen of India shall accept any title from any foreign state. 3. No person who is not a citizen of India shall, while he holds any office of profit or trust under the state, accept without the consent of the President any title from any foreign state. 4. No person holding any office of profit or trust under the state shall, without the consent of the President, accept any present, emolument, or office of any kind from or under any foreign state. Constitution of India. Part 3. Fundamental Rights. Right to freedom. Article 19. Protection of certain rights regarding freedom of speech, etc. All citizens shall have the right a. to freedom of speech and expression, b. to assemble peaceably and without arms, c. to form associations or unions or cooperative societies, d. to move freely throughout the territory of India, a. to reside and settle in any part of the territory of India, and g. to practice any profession, or to carry on any occupation, trade or business. Nothing in sub-clause A of clause 1 shall affect the operation of any existing law, or prevent the state from making any law, insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said sub-clause, in the interests of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement to an offence. Nothing in subclause B of the said clause shall affect the operation of any existing law insofar as it imposes, or prevent the state from making any law imposing, in the interests of the sovereignty and integrity of India or public order, reasonable restrictions on the exercise of the right conferred by the said subclause. Nothing in subclause C of the said clause shall affect the operation of any existing law insofar as it imposes, or prevent the state from making any law imposing, in the interests of the sovereignty and integrity of India or public order or morality, reasonable restrictions on the exercise of the right conferred by the said subclause. Nothing in subclauses D and A of the said clause shall affect the operation of any existing law insofar as it imposes, or prevent the state from making any law imposing, reasonable restrictions on the exercise of any of the rights conferred by the said subclauses, either in the interests of the general public, or for the protection of the interests of any scheduled tribe. Nothing in subclause G of the said clause shall affect the operation of any existing law, insofar as it imposes, or prevent the state from making any law imposing, in the interests of the general public, reasonable restrictions on the exercise of the right conferred by the said subclause, and, in particular, nothing in the said subclause shall affect the operation of any existing law, insofar as it relates to, or prevent the state from making any law relating to 1. The professional or technical qualifications necessary for practicing any profession, or carrying on any occupation, trade or business, or 2. The carrying on, by the state, or by a corporation, owned, or controlled by the state, of any trade, business, industry or service, whether to the exclusion, complete, or partial, of citizens, or otherwise. Constitution of India. Part 3. Fundamental Rights. Right to freedom. Article 20. Protection, in respect of conviction for offences. No person shall be convicted of any offence except for violation of a law, in force, at the time of the commission of the act, charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law, in force, at the time of the commission of the offence. No person shall be prosecuted and punished, for the same offence, more than once. No person accused of any offence shall be compelled to be a witness against himself. Constitution of India. Part 3. Fundamental Rights. Right to freedom. Article 21. Protection of life and personal liberty. No person shall be deprived of his life or personal liberty, except according to procedure established by law. Constitution of India. Part 3. Fundamental Rights. Right to freedom. Article 21. A. Right to education. The state shall provide free and compulsory education to all children of the age of 6 to 14 years, in such manner as the state may, by law, determine. Constitution of India. Part 3. Fundamental Rights. Right to freedom. Article 22. Protection against arrest and detention in certain cases. 1. No person who is arrested shall be detained in custody without being informed, as soon as may be, of the grounds for such arrest. Nor shall he be denied the right to consult, and to be defended by, a legal practitioner of his choice. 2. Every person who is arrested and detained in custody shall be produced before the nearest magistrate, within a period of 24 hours, of such arrest excluding the time necessary for the journey from the place of arrest, to the court of the magistrate, and no such person shall be detained in custody beyond the set period, without the authority of a magistrate. 3. Nothing in clauses 1 and 2 shall apply to any person who for the time being is an enemy alien, or to any person who is arrested or detained, under any law providing for preventive detention. 4. No law providing for preventive detention shall authorize the detention of a person, for a longer period than 3 months. Unless, an advisory board consisting of persons, who are, or have been, or are qualified to be appointed as, judges of a high court, has reported, before the expiration of the said period of 3 months, that there is in its opinion sufficient cause for such detention. Provided that nothing in this subclause shall authorize the detention of any person, beyond the maximum period prescribed by any law made by Parliament, under subclause B of clause 7. Or, such person is detained, in accordance with the provisions of any law made by Parliament, under subclauses A and B of clause 7. 5. When any person is detained in pursuance of an order made under any law, providing for preventive detention, the authority making the order shall, as soon as may be, communicate to such person the grounds on which the order has been made, and shall afford him the earliest opportunity of making a representation against the order. 6. Nothing in clause 5 shall require the authority making any such order, as is referred to in that clause, to disclose facts, which such authority considers to be against the public interest to disclose. 7. Parliament may by law prescribe a. The circumstances, under which in the class, or classes of cases, in which, a person may be detained for a period longer than 3 months, under any law providing for preventive detention, without obtaining the opinion of an advisory board, in accordance with the provisions of subclause A of clause 4. b. The maximum period, for which any person may in any class, or classes of cases, be detained, under any law providing for preventive detention. And c. The procedure to be followed by an advisory board, in an inquiry, under subclause A of clause 4. The Constitution of India. Part 3. Fundamental Rights. Right against exploitation. Article 23. Prohibition of traffic in human beings and forced labor. 1. Traffic in human beings, and beggar, and other similar forms of forced labor, are prohibited. And any contravention of this provision shall be an offense, punishable, in accordance with law. 2. Nothing in this article shall prevent the state from imposing compulsory service for public purposes. And in imposing such service, the state shall not make any discrimination on grounds only of religion, race, caste or class or any of them. The Constitution of India. Part 3. Fundamental Rights. Right against exploitation. Article 24. Prohibition of employment of children in factories, etc. No child below the age of 14 years shall be employed to work in any factory or mine, or engaged in any other hazardous employment. The Constitution of India. Part 3. Fundamental Rights. Right to freedom of religion. Article 25. Freedom of conscience, and free profession, practice and propagation of religion. 1. Subject to public order, morality and health, and, to the other provisions of this part, all persons are equally entitled to freedom of conscience, and the right, freely to profess, practice, and propagate religion. 2. Nothing in this article shall affect the operation of any existing law, or prevent the state from making any law, regulating or restricting any economic, financial, political or other secular activity which may be associated with religious practice. B. Providing for social welfare and reform, or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. Explanation 1. The wearing and carrying of kirpans shall be deemed to be included in the profession of the Sikh religion. Explanation 2. In subclause B of clause 2, the reference to Hindus shall be construed as including a reference to persons professing the Sikh, Jaina, or Buddhist religion, and the reference to Hindu religious institutions shall be construed accordingly. The Constitution of India. Part 3. Fundamental Rights. Right to freedom of religion. Article 26. Freedom to manage religious affairs. Subject to public order, morality and health, every religious denomination, or any section thereof, shall have the right a. To establish and maintain institutions for religious and charitable purposes. B. To manage its own affairs, in matters of religion. C. To own, and acquire, movable and immovable property, and D. To administer such property in accordance with law. The Constitution of India. Part 3. Fundamental Rights. Right to freedom of religion. Article 27. Freedom as to payment of taxes for promotion of any particular religion. No person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated in payment of expenses for the promotion or maintenance of any particular religion or religious denomination. The Constitution of India. Part 3. Fundamental Rights. Right to freedom of religion. Article 28. Freedom as to attendance at religious instruction, or religious worship, in certain educational institutions. 1. No religious instruction shall be provided in any educational institution, wholly maintained out of state funds. 2. Nothing in Clause 1 shall apply to an educational institution which is administered by the state, but has been established under any endowment or trust, which requires that religious instruction shall be imparted in such institution. 3. No person attending any educational institution recognized by the state, or receiving aid, out of state funds, shall be required to take part in any religious instruction that may be imparted in such institution, or to attend any religious worship that may be conducted in such institution or in any premises attached thereto, unless such person or, if such person is a minor, his guardian has given his consent thereto. The Constitution of India. Part 3. Fundamental Rights. Cultural and Educational Rights. Article 29. Protection of Interests of Minorities. 1. Any section of the citizens residing in the territory of India, or any part thereof having a distinct language, script, or culture of its own, shall have the right to conserve the same. 2. No citizen shall be denied admission into any educational institution, maintained by the state, or receiving aid, out of state funds, on grounds only of religion, race, caste, language or any of them. The Constitution of India. Part 3. Fundamental Rights. Cultural and Educational Rights. Article 30. Right of minorities to establish and administer educational institutions. 1. All minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. In making any law, providing for the compulsory acquisition of any property of an educational institution, established and administered by a minority, referred to in Clause 1. The state shall ensure that the amount fixed by or determined under such law, for the acquisition of such property, is such, as would not restrict or abrogate, the right guaranteed under that clause. 2. The state shall not, in granting aid to educational institutions, discriminate against any educational institution, on the ground that it is under the management of a minority, whether based on religion or language. The Constitution of India. Part 3. Fundamental Rights. Saving of certain laws. Article 31A. Saving of laws providing for acquisition of estates, etc. Notwithstanding anything contained in Article 13, no law providing for the acquisition by the state, of any estate or of any rights therein, or the extinguishment or modification of any such rights, or the taking over, of the management of any property by the state, for a limited period, either in the public interest, or in order to secure the proper management of the property, or the amalgamation of two or more corporations, either in the public interest, or in order to secure the proper management of any of the corporations, or the extinguishment or modification of any rights of managing agents, secretaries and treasurers, managing directors, or managers of corporations, or of any voting rights of shareholders thereof, or the extinguishment or modification of any rights accruing by virtue of any agreement, lease or license for the purpose of searching for, or winning, any mineral or mineral oil, or the premature termination or cancellation of any such agreement, lease or license, shall be deemed to be void on the ground that it is inconsistent with, or takes away or abridges, any of the rights conferred by Article 14 or Article 19. Provided that, where such law is a law, made by the legislature of a state, the provisions of this article shall not apply thereto, unless such law, having been reserved for the consideration of the President, has received his assent. Provided further, that, where any law, makes any provision for the acquisition by the state, of any estate and where any land comprised therein is held by a person under his personal cultivation, it shall not be lawful for the state to acquire any portion of such land, as is within the ceiling limit, applicable to him under any law for the time being in force, or any building or structure standing thereon or tenant thereto, unless the law relating to the acquisition of such land, building or structure, provides for payment of compensation, at a rate, which shall not be less than the market value thereof. In this article, the expression estate shall, in relation to any local area, have the same meaning as that expression, or its local equivalent has in the existing law, relating to land tenures in force, in that area, and shall also include any jagir, inam, or muafi, or other similar grant. And, in the states of Tamil Nadu and Kerala, any janmam right. Any land held under ryotwari settlement. Any land held, or let for purposes of agriculture, or for purposes ancillary thereto, including waste land, forest land, land for pasture, or sites of buildings, and other structures occupied by cultivators of land, agricultural laborers, and village artisans. The expression, rights, in relation to an estate, shall include any rights vesting in a proprietor, sub-proprietor, under-proprietor, tenureholder, rayat, under-rayat, or other intermediary and any rights, or privileges in respect of land revenue. The Constitution of India. Part 3. Fundamental Rights. Saving of certain laws. Article 31b. Validation of certain acts and regulations. Without prejudice to the generality of the provisions contained in Article 31a. None of the acts and regulations specified in the 9th schedule, nor any of the provisions thereof shall be deemed to be void, or ever to have become void on the ground that such act, regulation or provision is inconsistent with, or takes away or abridges any of the rights conferred by any provisions of this part. And, notwithstanding any judgment, decree or order of any court or tribunal, to the contrary, each of the said acts and regulations shall, subject to the power of any competent legislature to repeal, or amend it, continue in force. The Constitution of India. Part 3. Fundamental Rights. Saving of certain laws. Article 31c. Saving of laws giving effect to certain directive principles. Notwithstanding anything contained in Article 13. No law giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 shall be deemed to be void, on the ground that it is inconsistent with, or takes away or abridges any of the rights conferred by Article 14 or Article 19. And no law containing a declaration that it is for giving effect to such policy, shall be called in question in any court, on the ground that it does not give effect to such policy, provided that, where such law is made by the legislature of a state, the provisions of this article shall not apply thereto, unless such law, having been reserved for the consideration of the President, has received his assent. The Constitution of India. Part 3. Fundamental Rights. Right to constitutional remedies. Article 32. Remedies for enforcement of rights conferred by this part. 1. The right to move the Supreme Court, by appropriate proceedings for the enforcement of the rights conferred by this part, is guaranteed. 2. The Supreme Court shall have power to issue directions or orders, or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, whichever may be appropriate, for the enforcement of any of the rights conferred by this part. 3. Without prejudice to the powers conferred on the Supreme Court, by clauses 1 and 2. Parliament may by law empower any other court to exercise within the local limits of its jurisdiction all or any of the powers exercisable by the Supreme Court under Clause 2. 4. The right guaranteed by this article shall not be suspended, except as otherwise provided for by this Constitution. The Constitution of India. Part 3. Fundamental Rights. Right to constitutional remedies. Article 33. Power of Parliament, to modify the rights, conferred by this part, in their application to forces, etc. Parliament may by law, determine to what extent any of the rights, conferred by this part, shall, in their application to the members of the armed forces, or the members of the forces, charged with the maintenance of public order, or persons employed in any bureau, or other organization established by the state, for purposes of intelligence or counterintelligence, or person employed in, or in connection with, the telecommunication systems set up for the purposes of any force, bureau, or organization, referred to in clauses A to C, be restricted, or abrogated, so as to ensure the proper discharge of their duties, and the maintenance of discipline among them. The Constitution of India. Part 3. Fundamental Rights. Right to constitutional remedies. Article 34. Restriction on rights conferred by this part while martial law is in force in any area. Notwithstanding anything in the foregoing provisions of this part, Parliament may, by law, indemnify any person, in the service of the Union, or of a state, or any other person, in respect of any act done by him, in connection with the maintenance or restoration of order, in any area within the territory of India, where martial law was in force, or validate any sentence passed, punishment inflicted, forfeiture ordered, or other act done under martial law in such area. The Constitution of India. Part 3. Fundamental Rights. Right to constitutional remedies. Article 35. Legislation to give effect to the provisions of this part. Notwithstanding anything in this Constitution, Parliament shall have, and the legislature of a state shall not have, power to make laws, with respect to any of the matters, which, under Clause 3 of Article 16, Clause 3 of Article 32, Article 33 and Article 34 may be provided for, by law, made by Parliament, and for prescribing punishment, for those acts, which are declared to be offences under this part. And Parliament shall, as soon as may be after the commencement of this Constitution, make laws, for prescribing punishment, for the acts referred to in subclause 2. Any law, in force, immediately before the commencement of this Constitution, in the territory of India, with respect to any of the matters, referred to in subclause 1 of Clause A or providing for punishment for any act referred to in subclause 2 of that clause shall, subject to the terms thereof, and to any adaptations and modifications that may be made therein, under Article 372, continue in force until altered, or repealed, or amended, by Parliament. Explanation. In this article, the expression, law in force, has the same meaning as in Article 372. The Constitution of India. Part 4. Directive Principles of State Policy. Article 36. Definition. In this part, unless the context otherwise requires, the state has the same meaning as in Part 3. The Constitution of India. Part 4. Directive Principles of State Policy. Article 37. Application of the principles contained in this part. The provisions contained in this part shall not be enforceable by any court. But the principles therein laid down are, nevertheless, fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. The Constitution of India. Part 4. Directive Principles of State Policy. Article 38. State to secure social order, for the promotion of welfare of the people. The state shall strive to promote the welfare of the people, by securing and protecting as effectively as it may a social order, in which justice, social, economic, and political, shall inform all the institutions of the national life. The state shall, in particular, strive to minimize the inequalities in income, and endeavor to eliminate inequalities in status, facilities and opportunities, not only amongst individuals, but also amongst groups of people, residing in different areas, or engaged in different vocations. The Constitution of India. Part 4. Directive Principles of State Policy. Article 39. Certain principles of policy, to be followed, by the state. The state shall, in particular, direct, its policy towards securing, a. That the citizens, men and women equally, have the right, to an adequate means of livelihood, b. That the ownership and control of the material resources of the community, are so distributed as best to subserve, the common good. c. That the operation of the economic system, does not result in the concentration of wealth and means of production, to the common detriment. d. That there is equal pay, for equal work, for both men and women. a. That the health and strength of workers, men and women, and the tender age of children are not abused. And that citizens are not forced by economic necessity to enter avocations, unsuited to their age or strength. f. That children are given opportunities and facilities, to develop in a healthy manner, and in conditions of freedom and dignity. And that childhood and youth are protected against exploitation, and against moral and material abandonment. The Constitution of India. Part 4. Directive Principles of State Policy. Article 39A. Equal justice and free legal aid. The state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity, and shall, in particular, provide free legal aid by suitable legislation or schemes, or in any other way to ensure that opportunities for securing justice are not denied to any citizen, by reason of economic or other disabilities. The Constitution of India. Part 4. Directive Principles of State Policy. Article 40. Organization of Village Panchayats. The state shall take steps to organize village panchayats, and endow them with such powers and authority as may be necessary to enable them to function as units of self-government. The Constitution of India. Part 4. Directive Principles of State Policy. Article 41. Right to work, to education, and to public assistance, in certain cases. The state shall, within the limits of its economic capacity and development, make effective provision for securing the right to work, to education, and to public assistance, in cases of unemployment, old age, sickness, and disablement, and in other cases of undeserved want. The Constitution of India. Part 4. Directive Principles of State Policy. Article 42. Provision for just and humane conditions of work, and maternity relief. The state shall make provision for securing just and humane conditions of work, and for maternity relief. The Constitution of India. Part 4. Directive Principles of State Policy. Article 43. Living wage, etc., for workers. The state shall endeavor to secure, by suitable legislation, or economic organization or in any other way, to all workers, agricultural, industrial or otherwise, work, a living wage, conditions of work ensuring a decent standard of life, and full enjoyment of leisure, and social and cultural opportunities, and, in particular, the state shall endeavor to promote cottage industries, on an individual or cooperative basis, in rural areas. The Constitution of India. Part 4. Directive Principles of State Policy. Article 43A. Participation of workers in management of industries. The state shall take steps, by suitable legislation or in any other way, to secure the participation of workers in the management of undertakings, establishments, or other organizations engaged in any industry. The Constitution of India. Part 4. Directive Principles of State Policy. Article 43b. Promotion of cooperative societies. The state shall endeavor to promote voluntary formation, autonomous functioning, democratic control and professional management of cooperative societies. The Constitution of India. Part 4. Directive Principles of State Policy. Article 44. Uniform Civil Code for the Citizens. The state shall endeavour to secure for the citizens a uniform civil code throughout the territory of India. The Constitution of India. Part 4. Directive Principles of State Policy. Article 45. Provision for early childhood care and education to children below the age of 6 years. The state shall endeavour to provide early childhood care and education for all children until they complete the age of 6 years. The Constitution of India. Part 4. Directive Principles of State Policy. Article 46. Promotion of educational and economic interests of scheduled castes, scheduled tribes, and other weaker sections. The state shall promote with special care the educational and economic interests of the weaker sections of the people, and, in particular, of the scheduled castes and the scheduled tribes, and shall protect them from social injustice and all forms of exploitation. The Constitution of India. Part 4. Directive Principles of State Policy. Article 47. Duty of the state to raise the level of nutrition and the standard of living, and to improve public health. The state shall regard the raising of the level of nutrition and the standard of living of its people, and the improvement of public health, as among its primary duties, and, in particular, the state shall endeavour to bring about prohibition of the consumption, except for medicinal purposes, of intoxicating drinks and of drugs, which are injurious to health. The Constitution of India. Part 4. Directive Principles of State Policy. Article 48. Organization of Agriculture and Animal Husbandry. The state shall endeavor to organize agriculture and animal husbandry, on modern and scientific lines, and shall, in particular, take steps for preserving and improving the breeds, and prohibiting the slaughter of cows and calves and other milch and draught cattle. The Constitution of India. Part 4. Directive Principles of State Policy. Article 48A. Protection and improvement of environment, and safeguarding of forests and wildlife. The state shall endeavor to protect and improve the environment, and to safeguard the forests and wildlife of the country. The Constitution of India. Part 4. Directive Principles of State Policy. Article 49. Protection of monuments, and places, and objects of national importance. It shall be the obligation of the state to protect every monument, or place, or object of artistic, or historic interest, declared by, or under law made by Parliament to be of national importance, from spoliation, disfigurement, destruction, removal, disposal or export, as the case may be. The Constitution of India. Part 4. Directive Principles of State Policy. Article 50. Separation of judiciary from executive. The state shall take steps to separate the judiciary from the executive, in the public services of the state. The Constitution of India. Part 4. Directive Principles of State Policy. Article 51. Promotion of international peace and security. The state shall endeavor to a. Promote international peace and security. b. Maintain just and honorable relations between nations. c. Foster respect for international law and treaty obligations in the dealings of organized peoples with one another. And d. Encourage settlement of international disputes by arbitration. The Constitution of India. Part 4A. Fundamental Duties. Article 51A. Fundamental Duties. It shall be the duty of every citizen of India to abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem. B. To cherish and follow the noble ideals which inspired our national struggle for freedom. C. To uphold and protect the sovereignty, unity and integrity of India. D. To defend the country and render national service, when called upon to do so. A. To promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic and regional, or sectional diversities. To renounce practices derogatory to the dignity of women. F. To value and preserve the rich heritage of our composite culture. G. To protect and improve the natural environment, including forests, lakes, rivers and wildlife, and to have compassion for living creatures. H. To develop the scientific temper, humanism, and the spirit of inquiry and reform. I. To safeguard public property, and to abjure violence. J. To strive towards excellence in all spheres of individual and collective activity, so that the nation constantly rises to higher levels of endeavor and achievement. K. Who is a parent or guardian, to provide opportunities for education to his child, or, as the case may be, what between the age of 6 and 14 years. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 52. The President of India. There shall be a President of India. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 53. Executive power of the Union. 1. The executive power of the Union shall be vested in the President, and shall be exercised by him, either directly, or through officers, subordinate to him, in accordance with this Constitution. 2. Without prejudice to the generality of the foregoing provision, the supreme command of the defense forces of the Union shall be vested in the President, and the exercise thereof shall be regulated by law. 3. Nothing in this article shall be deemed to transfer to the President any functions conferred by any existing law on the government of any state, or other authority, or prevent Parliament from conferring by law functions on authorities other than the President. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 54. Election of President. The President shall be elected by the members of an electoral college, consisting of a. the elected members of both Houses of Parliament, and b. the elected members of the legislative assemblies of the states. Explanation. In this article, and in Article 55, state includes the National Capital Territory of Delhi, and the Union Territory of Pondicherry. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 55. Manner of election of President. 1. As far as practicable, there shall be uniformity in the scale of representation of the different states at the election of the President. 2. For the purpose of securing such uniformity among the states, inter se, as well as parity between the states as a whole and the Union, the number of votes, which each elected member of Parliament, and of the Legislative Assembly of each state, is entitled to cast at such election, shall be determined, in the following manner. A. Every elected member of the Legislative Assembly of a state shall have as many votes as there are multiples of 1,000. In the quotient obtained by dividing the population of the state by the total number of the elected members of the Assembly. B. If, after taking the said multiples of 1,000, the remainder is not less than 500, then the vote of each member referred to in subclause A shall be further increased by 1. C. Each elected member of either House of Parliament shall have such number of votes as may be obtained by dividing the total number of votes assigned to the members of the legislative assemblies of the states under subclauses A and B. by the total number of the elected members of both houses of parliament. Fractions exceeding one half being counted as one and other fractions being disregarded. 3. The election of the President shall be held in accordance with the system of proportional representation, by means of the single transferable vote, and the voting at such election shall be by secret ballot. Explanation. In this article, the expression population means the population as ascertained at the last preceding census, of which the relevant figures have been published. Provided that the reference in this explanation to the last preceding census, of which the relevant figures have been published shall, until the relevant figures for the first census taken after the year 2026 have been published, be construed as a reference to the 1971 census. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 56. Term of Office of President. 1. The President shall hold office for a term of 5 years, from the date on which he enters upon his office. Provided that a. The President may, by writing under his hand addressed to the Vice President, resign his office. b. The President may, for violation of the Constitution, be removed from office by impeachment in the manner provided in Article 61. c. The President shall, notwithstanding the expiration of his term, continue to hold office, until his successor enters upon his office. 2. Any resignation addressed to the Vice President under Clause A of the proviso to Clause 1 shall forthwith be communicated by him to the Speaker of the House of the People. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 57. Eligibility for re-election. A person who holds, or who has held, office as President shall, subject to the other provisions of this Constitution, be eligible for re-election to that office. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 58. Qualifications for election as President. 1. No person shall be eligible for election as President, unless he is a citizen of India, has completed the age of 35 years, and is qualified for election, as a member of the House of the People. 2. A person shall not be eligible for election as President if he holds any office of profit, under the Government of India, or the Government of any state, or under any local or other authority, subject to the control of any of the said governments. Explanation. For the purposes of this article, a person shall not be deemed to hold any office of profit, by reason only that he is the President or Vice President of the Union, or the Governor of any state, or as a minister either for the Union or for any state. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 59. Conditions of President's office. 1. The President shall not be a member of either House of Parliament, or of a House of the Legislature of any state. And, if a member of either House of Parliament or of a House of the Legislature of any state be elected President, he shall be deemed to have vacated his seat in that House, on the date on which he enters upon his office as President. 2. The President shall not hold any other office of profit. 3. The President shall be entitled without payment of rent to the use of his official residences, and shall be also entitled to such emoluments, allowances, and privileges as may be determined by Parliament by law. And, until provision in that behalf is so made, such emoluments, allowances and privileges, as are specified in the second schedule. 4. The emoluments and allowances of the President shall not be diminished during his term of office. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 60. Oath, or affirmation, by the President. Every President, and every person acting as President, or discharging the functions of the President, shall, before entering upon his office, make and subscribe in the presence of the Chief Justice of India, or, in his absence, the senior most judge of the Supreme Court available, an oath or affirmation in the following form, that is to say, I, A.B., do swear in the name of God, that I will faithfully execute the office, solemnly affirm of President, or discharge the functions of the President of India, and will to the best of my ability, preserve, protect and defend the Constitution, and the law, and that I will devote myself to the service and well-being of the people of India. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 61. Procedure for impeachment of the President. 1. When a President is to be impeached for violation of the Constitution, the charge shall be preferred by either House of Parliament. 2. No such charge shall be preferred unless the proposal to prefer such charge is contained in a resolution, which has been moved, after at least 14 days' notice in writing, signed by not less than 1/4 of the total number of members of the House, has been given of their intention to move the resolution. And such resolution has been passed by a majority of not less than 2/3 of the total membership of the House. 3. When a charge has been so preferred by either House of Parliament, the other House shall investigate the charge, or cause the charge to be investigated, and the President shall have the right to appear, and to be represented at such investigation. 4. If as a result of the investigation, a resolution is passed by a majority of not less than 2/3 of the total membership of the House, by which the charge was investigated, or caused to be investigated, declaring that the charge preferred against the President has been sustained, such resolution shall have the effect of removing the President from his office, as from the date on which the resolution is so passed. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 62. Time of holding election to fill vacancy in the office of President. And the term of office of person elected to fill casual vacancy. 1. An election to fill a vacancy caused by the expiration of the term of office of President, shall be completed before the expiration of the term. 2. An election to fill a vacancy in the office of President, occurring by reason of his death, resignation or removal, or otherwise shall be held as soon as possible, after, and in no case later than 6 months from, the date of occurrence of the vacancy. And the person elected to fill the vacancy shall, subject to the provisions of Article 56, be entitled to hold office for the full term of 5 years, from the date on which he enters upon his office. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 63. The Vice President of India. There shall be a Vice President of India. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 64. The Vice President, to be, ex officio Chairman of the Council of States. The Vice President shall be, ex officio Chairman of the Council of the States, and shall not hold any other office of profit, provided that, during any period, when the Vice President acts as President, or discharges the functions of the President under Article 65, he shall not perform the duties of the office of Chairman of the Council of States, and shall not be entitled to any salary, or allowance payable to the Chairman of the Council of States, under Article 97. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 65. The Vice President, to act as President, or to discharge his functions, during casual vacancies in the office, or during the absence of President. 1. In the event of the occurrence of any vacancy in the office of the President, by reason of his death, resignation, or removal, or otherwise, the Vice President shall act as President until the date on which a new President, elected, in accordance with the provisions of this chapter, to fill such vacancy, enters upon his office. 2. When the President is unable to discharge his functions, owing to absence, illness or any other cause, the Vice President shall discharge his functions, until the date on which the President resumes his duties. 3. The Vice President shall, during, and in respect of, the period while he is so acting as, or discharging the functions of President, have all the powers and immunities of the President, and be entitled to such emoluments, allowances and privileges, as may be determined by Parliament, by law. And, until provision in that behalf is so made, such emoluments, allowances and privileges, as are specified in the second schedule. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 66. Election of Vice President. 1. The Vice President shall be elected by the members of an electoral college, consisting of the members of both Houses of Parliament, in accordance with the system of proportional representation, by means of the single transferable vote, and the voting at such election shall be by secret ballot. 2. The Vice President shall not be a member of either House of Parliament, or of a House of the Legislature of any state. And, if a member of either House of Parliament, or of a House of the Legislature of any state be elected Vice President, he shall be deemed to have vacated his seat in that House, on the date on which he enters upon his office, as Vice President. 3. No person shall be eligible for election as Vice President, unless he is a citizen of India. B. Has completed the age of 35 years, and C. Is qualified for election, as a member of the Council of States. 4. A person shall not be eligible for election as Vice President, if he holds any office of profit, under the Government of India, or the Government of any state, or under any local, or other authority, subject to the control of any of the said governments. Explanation. For the purposes of this article, a person shall not be deemed to hold any office of profit, by reason only that he is the President or Vice President of the Union, or the Governor of any state, or is a minister either for the Union, or for any state. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 67. Term of office of Vice President. The Vice President shall hold office for a term of 5 years, from the date on which he enters upon his office. Provided that a. A Vice President may, by writing under his hand addressed to the President, resign his office. B. A Vice President may be removed from his office, by a resolution of the Council of States, passed by a majority of all the then members of the Council, and agreed to by the House of the People. But no resolution for the purpose of this clause shall be moved, unless at least 14 days' notice has been given, of the intention to move the resolution. C. A Vice President shall, notwithstanding the expiration of his term, continue to hold office, until his successor enters upon his office. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 68. Time of holding election to fill vacancy, in the office of Vice President. And the term of office of person elected to fill, casual vacancy. 1. An election, to fill a vacancy, caused by the expiration of the term of office of Vice President, shall be completed before the expiration of the term. 2. An election, to fill a vacancy, in the office of Vice President, occurring by reason of his death, resignation or removal, or otherwise shall be, held as soon as possible after the occurrence of the vacancy. And, the person elected, to fill the vacancy shall, subject to the provisions of Article 67, be entitled to hold office, for the full term of 5 years, from the date, on which, he enters upon his office. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 69. Oath, or affirmation, by the Vice President. Every Vice President shall, before entering upon his office, make and subscribe before the President, or some person appointed in that behalf, by him, an oath or affirmation, in the following form, that is to say, I, A.B, do swear in the name of God, that I will bear true faith and solemnly affirm allegiance to the Constitution of India, as by law established, and that I will faithfully discharge the duty upon which I am about to enter. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 70. Discharge of President's functions in other contingencies. Parliament may make such provision, as it thinks fit, for the discharge of the functions of the President, in any contingency, not provided for in this chapter. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 71. Matters relating to, or connected with, the election of a President or Vice President. 1. All doubts and disputes arising out of, or in connection with the election of a President, or Vice President shall be inquired into and decided by the Supreme Court, whose decision shall be final. 2. If the election of a person as President or Vice President is declared void by the Supreme Court, acts done by him in the exercise and performance of the powers and duties of the office of President or Vice President, as the case may be, on or before the date of the decision of the Supreme Court, shall not be invalidated by reason of that declaration. 3. Subject to the provisions of this Constitution, Parliament may by law regulate any matter relating to or connected with the election of a President or Vice President. 4. The election of a person as President or Vice President shall not be called in question on the ground of the existence of any vacancy, for whatever reason among the members of the Electoral College electing him. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 72. Power of President to grant pardons, etc. and to suspend, remit, or commute sentences in certain cases. 1. The President shall have the power to grant pardons, reprieves, respites, or remissions of punishment, or to suspend, remit, or commute the sentence of any person convicted of any offense, in all cases where the punishment or sentence is by a court-martial. B. In all cases where the punishment or sentence is for an offense against any law relating to a matter to which the executive power of the Union extends. C. In all cases where the sentence is a sentence of death. 2. Nothing in sub-clause A of clause 1 shall affect the power conferred by law on any officer of the armed forces of the Union to suspend, remit, or commute a sentence passed by a court-martial. 3. Nothing in sub-clause C of clause 1 shall affect the power to suspend, remit, or commute a sentence of death exercisable by the governor of a state under any law for the time being in force. The Constitution of India. Part 5. The Union. Chapter 1. The Executive. The President and Vice President. Article 73. Extent of executive power of the Union. 1. Subject to the provisions of this Constitution, the executive power of the Union shall extend to the matters with respect to which Parliament has power to make laws, and b. to the exercise of such rights, authority, and jurisdiction as are exercisable by the Government of India, by virtue of any treaty or agreement provided that the executive power referred to in subclause A shall not, save as expressly provided in this Constitution, or in any law made by Parliament, extend, in any state to matters with respect to which the legislature of the state has also power to make laws. 2. Until otherwise provided by Parliament, a state in any officer or authority of a state may, notwithstanding anything in this article, continue to exercise in matters, with respect to which Parliament has power to make laws for that state, such executive power or functions, as the state or officer, or authority thereof, could exercise immediately before the commencement of this Constitution. The Constitution of India, Part 5, The Union. Chapter 1. The Executive. Council of Ministers. Article 74. Council of Ministers, to aid and advise President. 1. There shall be a Council of Ministers, with the Prime Minister at the head, to aid and advise the President, who shall, in the exercise of his functions, act in accordance with such advice. Provided that the President may require the Council of Ministers to reconsider such advice, either generally or otherwise, and the President shall act in accordance with the advice tendered after such reconsideration. 2. The question whether any, and if so what, advice was tendered by ministers to the President shall not be inquired into in any court. The Constitution of India, Part 5, The Union. Chapter 1. The Executive. Council of Ministers. Article 75. Other provisions, as to ministers. 1. The Prime Minister shall be appointed by the President, and the other ministers shall be appointed by the President, on the advice of the Prime Minister. 1a. The total number of ministers, including the Prime Minister, in the Council of Ministers, shall not exceed 15% of the total number of members of the House of the People. 1b. A member of either House of Parliament, belonging to any political party, who is disqualified for being a member of that House, under paragraph 2, of the 10th schedule, shall also be disqualified to be appointed as a minister under clause 1. For duration of the period commencing from the date of his disqualification, till the date on which the term of his office as such member would expire, or, where he contests any election to either House of Parliament before the expiry of such period, till the date on which he is declared elected, whichever is earlier. 2. The ministers shall hold office during the pleasure of the President. 3. The Council of Ministers shall be collectively responsible to the House of the People. 4. Before a minister enters upon his office, the President shall administer to him the oaths of office and of secrecy according to the forms set out for the purpose in the third schedule. 5. A minister, who, for any period of 6 consecutive months, is not a member of either House of Parliament, shall at the expiration of that period, cease to be a minister. 6. The salaries and allowances of ministers shall be such as Parliament may from time to time by law determine, and, until Parliament so determines, shall be as specified in the second schedule. The Constitution of India. Part 5, The Union. Chapter 1. The Executive. Article 76. Attorney General for India. 1. The President shall appoint a person who is qualified to be appointed a judge of the Supreme Court to be Attorney General for India. 2. It shall be the duty of the Attorney General to give advice to the Government of India upon such legal matters, and to perform such other duties of a legal character as may from time to time be referred or assigned to him by the President, and to discharge the functions conferred on him by or under this Constitution or any other law for the time being in force. 3. In the performance of his duties, the Attorney General shall have right of audience in all courts in the territory of India. 4. The Attorney General shall hold office during the pleasure of the President, and shall receive such remuneration as the President may determine. The Constitution of India. Part 5, The Union. Chapter 1. The Executive. Conduct of Government Business. Article 77. Conduct of Business of the Government of India. 1. All executive action of the Government of India shall be expressed to be taken in the name of the President. 2. Orders, and other instruments, made and executed in the name of the President, shall be authenticated in such manner as may be specified in rules to be made by the President. And the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the President. 3. The President shall make rules for the more convenient transaction of the business of the Government of India, and for the allocation among ministers of the said business. The Constitution of India. Part 5, The Union. Chapter 1. The Executive. Conduct of Government Business. Article 78. Duties of Prime Minister, as respects the furnishing of information to the President, etc. It shall be the duty of the Prime Minister to communicate to the President all decisions of the Council of Ministers relating to the administration of the affairs of the Union, and proposals for legislation. B. To furnish such information relating to the administration of the affairs of the Union, and proposals for legislation, as the President may call for. And C. If the President so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister, but which has not been considered by the Council. The Constitution of India. Part 5, The Union. Chapter 2. Parliament. General. Article 79. Constitution of Parliament. There shall be a Parliament for the Union, which shall consist of the President, and 2 Houses, to be known respectively as the Council of States, and the House of the People. The Constitution of India. Part 5, The Union. Chapter 2. Parliament. General. Article 80. Composition of the Council of States. 1. The Council of States shall consist of 12 members to be nominated by the President, in accordance with the provisions of Clause 3. And b. Not more than 238 representatives of the states, and of the Union territories. 2. The allocation of seats, in the Council of States, to be filled by representatives of the states and of the Union territories, shall be in accordance with the provisions in that behalf contained in the 4th schedule. 3. The members to be nominated by the President under Sub-Clause A of Clause 1 shall consist of persons having special knowledge or practical experience in respect of such matters as the following, namely: literature, science, art and social service. 4. The representatives of each state, in the Council of States, shall be elected by the elected members of the Legislative Assembly of the state, in accordance with the system of proportional representation, by means of the single transferable vote. 5. The representatives of the Union territories in the Council of States shall be chosen in such manner as Parliament may by law prescribe. The Constitution of India. Part 5. The Union. Chapter 2. Parliament. General. Article 81. Composition of the House of the People. 1. Subject to the provisions of Article 331, the House of the People shall consist of a. Not more than 530 members chosen by direct election, from territorial constituencies in the states. And b. Not more than 20 members to represent the Union territories, chosen in such manner, as Parliament may by law provide. 2. For the purposes of sub-clause A of Clause 1. There shall be allotted to each state, a number of seats in the House of the People, in such manner, that the ratio between that number, and, the population of the state is, so far as practicable, the same for all states. And, b. Each state, shall be divided into territorial constituencies, in such manner, that the ratio between the population of each constituency, and, the number of seats allotted to it is, so far as practicable, the same throughout the state. Provided that, the provisions of sub-clause A of this clause, shall not be applicable, for the purpose of allotment of seats, in the House of the People, to any state, so long as the population of that state does not exceed 6 millions. 3. In this article, the expression population means the population is ascertained at the last preceding census, of which the relevant figures have been published. Provided that the reference, in this clause, to the last preceding census of which the relevant figures have been published, shall, until the relevant figures for the first census taken after the year 2026, have been published, be construed, 1. For the purposes of sub-clause A of Clause 2, and the proviso to that clause, as a reference to the 1971 census. And 2. For the purposes of sub-clause B of Clause 2, as a reference to the 2001 census. The Constitution of India. Part 5. The Union. Chapter 2. Parliament. General. Article 82. Readjustment after each census. Upon the completion of each census, the allocation of seats in the House of the People to the states, and the division of each state into territorial constituencies, shall be readjusted, by such authority, and in such manner as Parliament may by law determine. Provided that, such readjustment, shall not affect, representation in the House of the People, until the dissolution of the then existing House. Provided further that, such readjustment, shall take effect, from such date as the President may, by order, specify. And until such readjustment takes effect, any election to the House may be held, on the basis of the territorial constituencies existing before such readjustment. Provided also that, until the relevant figures, for the first census, taken after the year 2026, have been published, it shall not be necessary to readjust the allocation of seats in the House of the People to the states, as readjusted on the basis of the 1971 census. And 2. The division of each state into territorial constituencies, as may be readjusted, on the basis of the 2001 census, under this article. The Constitution of India, Part 5, The Union. Chapter 2, Parliament. General. Article 83. Duration of Houses of Parliament. 1. The Council of States shall not be subject to dissolution. But, as nearly as possible, 1/3 of the members thereof shall retire, as soon as may be on the expiration of every second year, in accordance with the provisions made in that behalf by Parliament, by law. 2. The House of the People, unless sooner dissolved, shall continue for 5 years from the date appointed for its first meeting, and no longer, and the expiration of the said period of 5 years, shall operate as a dissolution of the House, provided that the said period may, while a proclamation of emergency is in operation, be extended by Parliament by law, for a period not exceeding 1 year at a time, and not extending in any case beyond a period of 6 months, after the proclamation has ceased to operate. The Constitution of India, Part 5, The Union. Chapter 2, Parliament. General. Article 84. Qualification for membership of Parliament. A person shall not be qualified to be chosen to fill a seat in Parliament, unless he is a citizen of India, and makes and subscribes, before some person, authorized in that behalf by the Election Commission, an oath or affirmation according to the form set out for the purpose, in the third schedule. B. Is, in the case of a seat in the Council of States, not less than 30 years of age, and, in the case of a seat in the House of the People, not less than 25 years of age. And, C. Possesses such other qualifications, as may be prescribed, in that behalf, by or under, any law made by Parliament. The Constitution of India, Part 5, The Union. Chapter 2, Parliament. General. Article 85. Sessions of Parliament, Prorogation, and Dissolution. 1. The President shall from time to time summon each House of Parliament to meet at such time and place as he thinks fit. But 6 months shall not intervene between its last sitting in one session, and the date appointed for its first sitting in the next session. 2. The President may from time to time prorogue the Houses, or either House. B. Dissolve the House of the People. The Constitution of India. Part 5. The Union. Chapter 2. Parliament. General. Article 86. Right of President to address and send messages to Houses. 1. The President may address either House of Parliament or both Houses assembled together, and, for that purpose, require the attendance of members. 2. The President may send messages to either House of Parliament, whether with respect to a bill then pending in Parliament, or otherwise. And a House to which any message is so sent, shall, with all convenient dispatch, consider any matter required by the message to be taken into consideration. The Constitution of India. Part 5. The Union. Chapter 2. Parliament. General. Article 87. Special Address by the President. 1. At the commencement of the first session after each general election, to the House of the People, and, at the commencement of the first session of each year, the President shall address both Houses of Parliament assembled together, and inform Parliament of the causes of its summons. 2. Provision shall be made by the rules regulating the procedure of either House for the allotment of time for discussion of the matters referred to in such address. The Constitution of India. Part 5. The Union. Chapter 2. Parliament. General. Article 88. Rights of Ministers and Attorney General. As respects Houses, every Minister and the Attorney General of India shall have the right to speak in, and otherwise to take part in the proceedings of either House, any joint sitting of the Houses, and any committee of Parliament, of which he may be named a member, but shall not by virtue of this article be entitled to vote. The Constitution of India. Part 5, The Union. Chapter 2. Parliament. Officers of Parliament. Article 89. The Chairman and Deputy Chairman of the Council of States. 1. The Vice President of India shall be ex officio Chairman of the Council of States. 2. The Council of States shall, as soon as may be, choose a member of the Council to be Deputy Chairman thereof, and, so often as the office of Deputy Chairman becomes vacant, the Council shall choose another member to be Deputy Chairman thereof. The Constitution of India. Part 5, The Union. Chapter 2. Parliament. Officers of Parliament. Article 90. Vacation and resignation of, and removal from, the office of Deputy Chairman. A member holding office, as Deputy Chairman of the Council of States, shall vacate his office if he ceases to be a member of the Council. B. May at any time, by writing under his hand addressed to the Chairman, resign his office. And C. May be removed from his office, by a resolution of the Council, passed by a majority of all the then members of the Council. Provided that, no resolution for the purpose of Clause C, shall be moved, unless at least 14 days' notice has been given of the intention to move the resolution. The Constitution of India. Part 5, The Union. Chapter 2. Parliament. Officers of Parliament. Article 91. Power of the Deputy Chairman, or other person, to perform the duties of the office of, or to act as, Chairman. 1. While the office of Chairman is vacant, or during any period when the Vice President is acting as, or discharging the functions of President, the duties of the office shall be performed by the Deputy Chairman. Or, if the office of Deputy Chairman is also vacant, by such member of the Council of States as the President may appoint for the purpose. 2. During the absence of the Chairman from any sitting of the Council of States, the Deputy Chairman, or, if he is also absent, such person as may be determined by the rules of procedure of the Council, or, if no such person is present, such other person as may be determined by the Council, shall act as Chairman. The Constitution of India. Part 5, The Union. Chapter 2. Parliament. Officers of Parliament. Article 92. The chairman or the deputy chairman, not to preside, while a resolution for his removal from office is under consideration. 1. At any sitting of the Council of States, while any resolution for the removal of the Vice President from his office is under consideration, the chairman, or while any resolution for the removal of the deputy chairman from his office is under consideration, the deputy chairman shall not, though he is present, preside. And, the provisions of Clause 2 of Article 91 shall apply in relation to every such sitting, as they apply in relation to a sitting from which the chairman, or, as the case may be, the deputy chairman, is absent. 2. The chairman shall have the right to speak in, and, otherwise to take part in the proceedings of, the Council of States, while any resolution for the removal of the Vice President from his office is under consideration in the Council, but, notwithstanding anything in Article 100, shall not be entitled to vote at all on such resolution, or on any other matter during such proceedings. The Constitution of India. Part 5. The Union. Chapter 2. Parliament. Officers of Parliament. Article 93. The Speaker and Deputy Speaker of the House of the People. The House of the People shall, as soon as may be, choose 2 members of the House, to be respectively Speaker and Deputy Speaker thereof, and so often as the office of Speaker or Deputy Speaker becomes vacant, the House shall choose another member to be Speaker or Deputy Speaker, as the case may be. The Constitution of India. Part 5. The Union. Chapter 2. Parliament. Officers of Parliament. Article 94. Vacation and resignation of, and removal from, the offices of Speaker and Deputy Speaker. A member holding office as Speaker, or Deputy Speaker of the House of the People, shall vacate his office if he ceases to be a member of the House of the People. B. May at any time, by writing under his hand addressed, if such member is the Speaker, to the Deputy Speaker, and, if such member is the Deputy Speaker, to the Speaker, resign his office, and, c. may be removed from his office by a resolution of the House of the People, passed by a majority of all the then members of the House, provided that no resolution for the purpose of Clause C shall be moved, unless at least 14 days' notice has been given of the intention to move the resolution. Provided further that, whenever the House of the People is dissolved, the Speaker shall not vacate his office, until immediately before the first meeting of the House of the People, after the dissolution. The Constitution of India. Part 5, The Union. Chapter 2. Parliament. Officers of Parliament. Article 95. Power of the Deputy Speaker, or other person, to perform the duties of the office of, or to act as, Speaker. 1. While the office of Speaker is vacant, the duties of the office shall be performed by the Deputy Speaker. Or, if the office of Deputy Speaker is also vacant, by such member of the House of the People as the President may appoint for the purpose. 2. During the absence of the Speaker from any sitting of the House of the People, the Deputy Speaker, or, if he is also absent, such person as may be determined by the rules of procedure of the House, or, if no such person is present, such other person as may be determined by the House, shall act as Speaker. The Constitution of India. Part 5, The Union. Chapter 2. Parliament. Officers of Parliament. Article 96. The Speaker or the Deputy Speaker, not to preside, while a resolution for his removal from office is under consideration. 1. At any sitting of the House of the People, while any resolution for the removal of the Speaker from his office is under consideration, the Speaker, or while any resolution for the removal of the Deputy Speaker from his office is under consideration, the Deputy Speaker shall not, though he is present, preside. And the provisions of Clause 2 of Article 95 shall apply, in relation to every such sitting, as they apply in relation to a sitting from which the Speaker, or, as the case may be, the Deputy Speaker, is absent. 2. The Speaker shall have the right to speak in, and otherwise to take part in, the proceedings of the House of the People, while any resolution for his removal from office is under consideration in the House. And shall, notwithstanding anything in Article 100, be entitled to vote, only in the first instance, on such resolution, or on any other matter during such proceedings. But not, in the case of an equality of votes. The Constitution of India. Part 5, The Union. Chapter 2. Parliament. Officers of Parliament. Article 97. Salaries and allowances of the Chairman, and Deputy Chairman, and the Speaker, and Deputy Speaker. There shall be paid to the Chairman, and the Deputy Chairman, of the Council of States, and to the Speaker, and the Deputy Speaker of the House of the People, such salaries and allowances, as may be respectively fixed by Parliament by law. And, until provision in that behalf is so made, such salaries and allowances as is specified in the second schedule. The Constitution of India. Part 5, The Union. Chapter 2. Parliament. Officers of Parliament. Article 98. Secretariat of Parliament. 1. Each House of Parliament shall have a separate secretarial staff. Provided that, nothing in this clause shall be construed as preventing the creation of posts common to both Houses of Parliament. 2. Parliament may by law regulate the recruitment and the conditions of service of persons appointed to the secretarial staff of either House of Parliament. 3. Until provision is made by Parliament under Clause 2. The President may, after consultation with the Speaker of the House of the People, or the Chairman of the Council of States, as the case may be, make rules regulating the recruitment and the conditions of service of persons appointed to the secretarial staff of the House of the People or the Council of States. And any rules so made shall have effect, subject to the provisions of any law made under the said clause. The Constitution of India. Part 5, The Union. Chapter 2. Parliament. Conduct of Business. Article 99. Oath or affirmation by members. Every member of either House of Parliament shall, before taking his seat, make and subscribe before the President, or some person appointed in that behalf by him, an oath or affirmation according to the form set out for the purpose in the third schedule. The Constitution of India. Part 5, The Union. Chapter 2. Parliament. Conduct of Business. Article 100. Voting, in Houses, power of Houses to act, notwithstanding vacancies and quorum. 1. Save as otherwise provided in this Constitution, all questions at any sitting of either House, or joint sitting of the Houses, shall be determined by a majority of votes, of the members present and voting, other than the Speaker or person acting as Chairman or Speaker. The Chairman or Speaker, or person acting as such, shall not vote in the first instance, but shall have and exercise a casting vote, in the case of an equality of votes. 2. Either House of Parliament shall have power to act, notwithstanding any vacancy in the membership thereof, and any proceedings in Parliament shall be valid, notwithstanding that it is discovered subsequently that some person who was not entitled so to do, sat or voted, or otherwise took part in the proceedings. 3. Until Parliament by law otherwise provides, the quorum to constitute a meeting of either House of Parliament shall be 1/10 of the total number of members of the House. 4. If at any time during a meeting of a House there is no quorum, it shall be the duty of the Chairman or Speaker, or person acting as such, either to adjourn the House or to suspend the meeting until there is a quorum. The Constitution of India. Part 5, The Union. Chapter 2. Parliament. Disqualifications of members. Article 101. Vacation of seats. 1. No person shall be a member of both Houses of Parliament. And, provision shall be made by Parliament, by law, for the vacation by a person, who is chosen a member of both houses of his seat, in one house, or the other. 2. No person shall be a member both of Parliament and of a house of the legislature of a state. And, if a person is chosen a member both of Parliament and of a house of the legislature of a state, then, at the expiration of such period as may be specified in rules made by the President, that person's seat in Parliament shall become vacant, unless he has previously resigned his seat in the legislature of the state. 3. If a member of either House of Parliament becomes subject to any of the disqualifications mentioned in Clause 1 or Clause 2, of Article 102, or resigns his seat, by writing under his hand addressed to the Chairman or the Speaker, as the case may be, and his resignation is accepted by the Chairman or the Speaker, as the case may be, his seat shall thereupon become vacant. Provided that, in the case of any resignation referred to in sub-clause B, if, from information received or otherwise, and, after making such inquiry, as he thinks fit, the Chairman or the Speaker, as the case may be, is satisfied that such resignation is not voluntary or genuine, he shall not accept such resignation. 4. If for a period of 60 days, a member, of either House of Parliament, is, without permission of the House, absent from all meetings thereof, the House may declare his seat vacant. Provided that, in computing the said period of 60 days, no account shall be taken, of any period, during which, the House is prorogued, or, is adjourned for more than 4 consecutive days. The Constitution of India. Part 5, The Union. Chapter 2. Parliament. Disqualifications of members. Article 102. Disqualifications for membership. 1. A person shall be disqualified for being chosen as, and for being, a member of either House of Parliament, a. If he holds any office of profit under the Government of India, or the government of any state, other than an office declared by Parliament by law, not to disqualify its holder. B. If he is of unsound mind, and stands so declared by a competent court. C. If he is an undischarged insolvent. D. If he is not a citizen of India, or has voluntarily acquired the citizenship of a foreign state, or is under any acknowledgement of allegiance, or adherence to a foreign state. A. If he is so disqualified, by or under any law made by Parliament. Explanation. For the purposes of this clause, a person shall not be deemed to hold an office of profit under the Government of India or the Government of any state, by reason only that he is a minister either for the Union, or for such state. 2. A person shall be disqualified for being a member of either House of Parliament, if he is so disqualified under the 10th schedule. The Constitution of India. Part 5, The Union. Chapter 2. Parliament. Disqualifications of members. Article 103. Decision on questions as to disqualifications of members. 1. If any question arises as to whether a member of either House of Parliament has become subject to any of the disqualifications mentioned in Clause 1 of Article 102, the question shall be referred for the decision of the President and his decision shall be final. 2. Before giving any decision on any such question, the President shall obtain the opinion of the Election Commission, and shall act according to such opinion. The Constitution of India. Part 5, The Union. Chapter 2. Parliament. Disqualifications of members. Article 104. Penalty for sitting and voting before making oath or affirmation under Article 99, or, when not qualified, or when disqualified. If a person sits or votes as a member of either House of Parliament, before he has complied with the requirements of Article 99, or, when he knows that he is not qualified, or that he is disqualified for membership thereof, or, that he is prohibited from so doing by the provisions of any law made by Parliament, he shall be liable in respect of each day on which he so sits or votes, to a penalty of 500 rupees, to be recovered as a debt due to the Union. The Constitution of India. Part 5, The Union. Chapter 2. Parliament. Powers, privileges and immunities of Parliament, and its members. Article 105. Powers, privileges, etc., of the Houses of Parliament, and of the members and committees thereof. 1. Subject to the provisions of this Constitution, and to the rules and standing orders regulating the procedure of Parliament, there shall be freedom of speech in Parliament. 2. No member of Parliament shall be liable to any proceedings in any court, in respect of anything said, or any vote given by him in Parliament, or any committee thereof, and no person shall be so liable in respect of the publication, by or under, the authority of either House of Parliament of any report, paper, votes, or proceedings. 3. In other respects, the powers, privileges and immunities of each House of Parliament, and of the members and the committees of each House, shall be such as may from time to time be defined by Parliament by law. And, until so defined, shall be those of that House and, of its members, and committees, immediately before the coming into force of Section 15 of the Constitution, 44th Amendment, Act, 1978. 4. The provisions of clauses 1, 2, and 3 shall apply in relation to persons who by virtue of this Constitution have the right to speak in, and otherwise to take part in the proceedings of, a House of Parliament, or any committee thereof, as they apply in relation to members of Parliament. The Constitution of India. Part 5, The Union. Chapter 2. Parliament. Powers, privileges and immunities of Parliament, and its members. Article 106. Salaries and allowances of members. Members of either House of Parliament shall be entitled to receive such salaries and allowances as may from time to time be determined by Parliament by law. And, until provision in that respect is so made, allowances at such rates, and upon such conditions, as were immediately before the commencement of this Constitution, applicable in the case of members of the Constituent Assembly of the Dominion of India.